to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Venstall-Dynan, and joining me is Al Parsai, RCIC-IRB. Welcome, Al.
Hi, Rosalie. Thanks for the invite.
A pleasure to have you. Al, would you walk us through the Slepcskik and Canada decision?
Of course. So Slepcskik is actually a fascinating case, and I was following this along from the beginning when Barbara Jackman and her team filed that with federal court. So the case is important because of two major reasons. Let me just give you a little bit of background. So Mr. Slepcskik comes to Canada. He's a Czech Republic citizen, but from Roma ethnicity, and he files a refugee claim in 1997. And that refugee claim is granted. But the entity that grants that refugee claim is called CRDD, which is the predecessor to RPD, or Refugee Protection Division. He becomes a protected person. He later becomes a permanent resident. But after becoming permanent resident, he travels back to Czech Republic several times. On one of his travels back to Canada, the CBSA officer says, are you traveling back to the same place that you claimed refugee from? And he answers yes, and he eventually jokes about it and says, maybe I need to apply for Canadian citizenship now. But of course, CBSA moves forward with this, and they filed a cessation request to RPD. Now, cessation hearing means that you either reavailed yourself to the country that you sought refugee from and protection from, or the conditions in that country has changed. Refugee Protection Division initially says, we don't have jurisdiction because the original decision was made by CRDD, not by RPD, and I cannot seize a decision made by another entity. The minister files again, and this time RPD agrees to hear the cessation, and they seize the protection of Mr. Slepcskik based on the reavailment, because they say that you acquired the Czech passport actually multiple times, you traveled there multiple times, and then they take away his protection. Now, there was a change under Section 46 of the Immigration Act in 2012 or 2013, where they added a section to Section 46, which says that if you lose your protection because of reavailment, you also automatically lose your permanent residence. So the judicial review filing, among other things, they focused on two important matters. Important matter number one is that can RPD seize the protection of a person that the decision was made by CRDD. And number two was that automatic loss of permanent residence because you lose your protection, is it constitutional or not? And they refer to many sections of the Constitution and charter rights challenges. Unfortunately, the federal court agreed with the minister on all of those accounts. And they said, you know what, this RPD can, in fact, make decisions about CRDD decisions. And the second one, they said there are no charter breaches here by referring to cessation and then automatically taking away permanent residency. However, that's the important piece, is that they certified two major questions. And one of those questions was that, again, the same central question that whether RPD can, in fact, reject decisions made by CRDD, and the second was charter challenges. And now this case is in front of Federal Court of Appeal. In fact, it was filed on December 10th with Federal Court of Appeal. We need to wait how the Federal Court of Appeal will look at that. But I think the most important piece would be, we know that for now, if a person who is a permanent resident, they reavail themselves to their home country, for example, by acquiring new passports or traveling back to that country or living in that country, they automatically lose their permanent residence as well.
Great. Well, thank you so much, Al, for unpacking that case law for us, this evolving case law. What an important thing to highlight for us working with our own clients. Thank you for flagging that.
Thank you. Thank you very much, Rosalie.
Let's talk again.